Welcome to the second Tanner lecture by Robert Post, entitled Campaign Finance Reform and the First Amendment. After having given us an immersive historical account of the vicissitudes of representation in the tradition of American democracy yesterday, we look forward to Robert Post coming head-to-head with Citizens United today. Frank Michelman, the Robert Walmsley University Professor Emeritus, has very generously agreed to introduce the second lecture. My intention to provide a pithy introduction to Professor Michelman was defeated earlier this afternoon when I read the voluminous tributes to him in the February 2012 issue of the Harvard Law Review. It is impossible to say anything in a few words that matches either the stature of his scholarship or adequately describes his skill in playing drop the needle and identifying any piece of classical music on the evidence of a few bars. Somebody who can bring both those things together has to speak for himself. Friends, join me in welcoming Professor Michelman, and after the lecture, Larry Lessig will give us will be the discussant, and after that discussion, we will open up to the audience. Thank you very much for being here today.
Well, with my dear friend, my dear and much admired friend, Robert, sitting right there beside me, I have to start by saying what a special privilege it is for me to be heralding this second of Robert's Tanner lectures. I think that when Homi Bhabha invited me to start us off this afternoon, it was with an inkling of some past engagement on my part with Dean Post's First Amendment scholarship. So I'm going to respond in kind with a thought about how one might have gathered from that past body of work an anticipation of the Postian theory of campaign finance, which is being revealed to us this afternoon. And then we'll hand it back over to Robert for verification or falsification, as the case may be. My text is one short remark from Robert's landmark work on the First Amendment of 1995, the book Constitutional Domains. And here's the text. Democratic self-government requires particular social arrangements for its realization. If public discourse is kept free for the autonomous participation of individual citizens, and if government decision-making is subordinated to the public opinion produced by public discourse, two conditions, then there is the possibility that citizens will come to identify with the state as representative of their own self-determination. That's the text. It reduces to the shortest possible compass what we can aptly call a value-based, a descriptive, and a sociological account of the First Amendment. Value-based because it explains the First Amendment in terms of the pursuit of a political value, democratic self-government, that it both treats as true and holds to be supremely important. Descriptive because it offers its account of that value and of the means of that value's possible achievement in modern state conditions as the best fitting explanation for the actual overall course of First Amendment doctrine as we have it. Of course, Dean Post doesn't stand alone in touting the protection of democracy as the point and core of the First Amendment. But that's where sociological comes in. Robert shares with others a premise that fulfillment of democratic self-government is a requirement for political legitimacy in this country now. But political legitimacy for Robert cannot be understood, or it cannot be understood only, as a matter of the regime's formal compliance with abstract or even with locally agreed principles of right, formal compliance with principles. Democratic legitimacy is also irreducibly a matter of the actual subjective and social experience of citizens, their experience of engagement in self-government. And so, for Robert Post, the question of democracy becomes quite insistently a sociological question, a question about how such an experience can possibly and validly be sustained for every individual citizen in modern state conditions of size, diversity, and mediatization. Well, I've already read out Robert's answer from 1995. That answer posits not one but two necessary conditions for success. If public discourse is kept free for the autonomous participation of individual citizens, and if government decision-making is subordinated to the public opinion produced by public discourse, then there is the possibility that citizens, subjectively, will come to identify with the state as representative of their own self-determination. Well, there are technical notions there to reckon with: public discourse, public opinion, and the idea of a relationship of production between the two. And I expect we'll hear something about those pretty soon. In Robert's past works, the lion's share of the attention has gone to working out the implications of the first necessary condition for modern democratic legitimacy, the condition that public discourse be kept free for the autonomous inputs of individual citizens. We may hope and expect that this afternoon's lecture and the Tanner lectures as a whole will bring to fruition some implications of the other necessary condition, the condition of the credible subordination of government decision-making to the public opinion produced by public discourse. And now we're going to find out.
As is characteristically correct, Frank picked the exact right sentence. I might as well sit down right now. It's all there. We're going to pick up today in light of yesterday's discussion. Yesterday we talked about the history of the value of self-government in the United States, and we saw that in the progressive era, self-government began to lodge in this idea of public opinion, which leads in turn to the notion of communicative rights, which determine what sort of public opinion can carry the burden of self-governance. And we put on the table an hypothesis about why First Amendment rights emerge suddenly in this country after a period of more than a century, emerge as judicially enforceable. And that hypothesis is that suddenly public opinion becomes the site of self-government in a way that it wasn't prior to the progressive era, in a way that party had really assumed that role up until the end of the 19th century. And so the First Amendment doctrine develops out of this emphasis on what yesterday I called discursive democracy, and the kind of First Amendment rights that the Citizens United, as an opinion, tries to articulate and defend in its opinion, is plainly the heritage of this history. And so we see in that opinion Justice Kennedy saying, quote, "Speech is an essential mechanism of democracy, for it is the means to hold officials accountable to the people. The right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to enlighten self-government and a necessary means to protect it." And Kennedy concludes from that in Citizens United, the First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office. And that seems to be more or less unobjectionable, given the derivation that I traced yesterday of the meaning of First Amendment rights and their significance. So what we're going to try to explore today is, if one understands this as the purpose, as the telos of First Amendment rights, what does it tell us about the issues of campaign finance reform? Before we get there, there is one preliminary issue that I just want to mention. I won't spend a lot of time on it. And that is, one sees a number of very prominent people who make the argument that well, the First Amendment has nothing to do with campaign finance reform because money is not speech. Speech is not money. One sees John Paul Stevens makes that remark, J. Skelly Wright, a number of rather important figures in our jurisprudence have said that. I just want to say at the outset and very briefly, I find that argument more or less untenable for a number of reasons, but I'll just mention two quickly here. One, First Amendment questions arise not merely because of what is being regulated, they arise also because why something is being regulated. Right? So whether or not money is speech, if legislation is enacted for the wrong reason, we have a First Amendment problem. So a simple example might be campaign finance reform that says Democrats can't have independent expenditures, but Republicans can. Right? Regardless of whether that's money and whether money is speech, you're going to have a First Amendment problem with that legislation because of its purpose or motivation or what it's trying to achieve. And so even if money were not speech, even if we accepted the premise, it wouldn't follow that you don't have a First Amendment problem. That's the first point. Second point is the people who make this objection have imagine communication as something abstract, as immaterial, as not embodied in some physical substrate, but there is no such communication. If I'm talking to you, it's through sound waves. If I'm having a parade, it's through the physicality of the parade. If I have a newspaper, it's through newsprint. And the regulation of the physical medium through which or by means of which speech happens is often, for constitutional purposes, appropriately treated as the regulation of the speech itself. So if you imagine a law in which, let's say, politicians decide that they've had enough of the scrutiny by the press, so there can be no biographies sold of present political officials. You can't write a biography of some active political official and sell it in the market. People would regard that as an attempt to suppress the biographies of contemporary political officials, whether or not it's regulating the money, and that would be perfectly appropriate. And there are many First Amendment opinions which more or less hold this. So for these two reasons, I don't regard the argument that the First Amendment has no application here because it's about money as a cogent argument. And so the issue on the table is not whether the First Amendment should apply, but how it should apply, what sort of scrutiny we should have here. So to answer that question, we have to actually look at the specifics of the regulation at issue in Citizens United, and that statute is Section 441B of the Bipartisan Campaign Reform Act of 2002, affectionately known to insiders as BICRA. So when I use the word BICRA, I'm referring to that statute. And this provision of the statute prohibits independent expenditures by the Treasury Fund of corporations, quote, for speech defined as an electioneering communication or for speech expressly advocating the election or defeat of a candidate. So we're considering the constitutionality of a statutory provision that prohibits corporations from spending directly their own treasury funds to advocate the defeat or the election of a particular candidate in an election. Let's just make it simple like that. And if we look to the court's opinion, it's, to put it mildly, not a model of clarity. It's a little hard to know at any given moment what are the essential principles of the court's reasoning. But at a minimum, we know from Kennedy's opinion that the court says this is a regulation of speech, of political speech. It's a regulation of speech at the core of the First Amendment, and therefore it should be subject to strict scrutiny, which means that the legislation can be constitutional only if the government can prove that it furthers a compelling interest and is narrowly tailored to that interest. And a good deal of the court's majority opinion in Citizens United is devoted to the proposition that this section of BICRA, banning the independent expenditures by corporations, does not serve any compelling governmental interest. And therefore, it's unconstitutional because it passes this preliminary test of strict scrutiny. No compelling interest here, hence unconstitutional. So in the traditional literature of campaign finance reform, one sees three interests advanced to support campaign finance regulation of the kind that we're considering in BICRA. These three interests are first, equality, second, distortion, and third, eliminating corruption. And I want to say at the outset, each of these three interests makes perfectly good sense within the context of a representative system. If we're looking at self-government as embodied in a system of representation, every one of these three interests makes a great deal of sense. The issue for the court, however, is does it make sense within the context of the First Amendment, which means, to adopt the terms I discussed and defined yesterday, does it make sense within the regime of a discursive democracy? whether these can be viewed as compelling interests when measured by the tests and the premises and the normative framework of discursive democracy. That's the question which we're going to look at now. So let me take up each of those three interests in order. The first is equality. Now, equality is a central principle of our system of representation. Indeed, it's constitutionally compelled. As the court famously said in Reynolds versus Sims, quote, full and effective participation by all citizens in state government requires that each citizen have an equally effective voice in the election of members of his state legislature. Right? So the Constitution demands one person, one vote. It demands an equal influence in the outcome of the election, which is to say, in the decision-making process by which we select representatives. And in other countries in the world, this principle of equality has been given constitutional status in the context of campaign finance reform. So in Canada, as I mentioned yesterday in response to Michael Ignatius' question, in the decision of Harper versus Canada, the Canadian court upheld very stringent campaign finance reform on the ground that individuals should have an equal opportunity to participate in the electoral process and that wealth is the main obstacle to equal participation. And so we have, says the Canadian Supreme Court, an egalitarian model of elections, which then expands into electoral speech. And therefore, speech should be regulated on the principle of equality. Our Supreme Court, in contrast to Canada, has specifically rejected equality as an interest which can justify the regulation of speech. In the very first of the modern decisions dealing with campaign finance reform, Buckley versus Vallejo, 1976, the court tells us that the court rejects the idea, quote, that a governmental interest in equalizing the relative ability of individuals and groups to influence the outcome of elections can justify restrictions on campaign expenditures. And in a famous passage, the court says, quote, the concept that the government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment, which was designed to secure the widest possible dissemination of information from diverse and antagonistic sources and to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people. So the question is, why does our court reject the notion of equality where the Canadian court embraces it? It's interesting. The Canadian court is dealing with a constitution that has two rights, a right to representation and a right to freedom of speech. And basically, the Canadian court says the right to representation trumps. So why is it that equality makes sense within representation? Because we have a decision to make. Who's going to represent us? And each of us has, ex ante, an equal right to participate and influence that decision. It makes perfect sense to allocate decision-making powers equally with respect to those who have a stake in the outcome of the decision, which we all do, since we're all voting. Well, if we now turn to discursive democracy, the interesting thing about it, as we discovered yesterday, is that in discursive democracy, there is no decision-making. In discursive democracy, public opinion is an ongoing, never-ending, continuously evolving process. So there is no decision with respect to which any given citizen can exercise equal influence. Public opinion is always moving, and everyone is participating in it. With regard to what could people be equal? Well, the way our First Amendment jurisprudence unpacks this, everyone has the equal right to participate, to be part of that process, but they don't have the equal right to influence it because there's no outcome that is the influence. Now, that point about equality is a deep one. I'm going to now introduce a term called public discourse that Frank mentioned earlier, and I'm going to define public discourse as the communicative processes by which persons participate in the formation of public opinion. And the First Amendment rights apply to those speech acts which we view as necessary, constitutionally necessary for the formation of public opinion. And so we will talk about rights of participation in public discourse as protected by the First Amendment. Why do we protect those rights? I argued yesterday that we can see, coming out of the progressive era, we protect those rights so that persons can experience the state as democratically legitimate with respect to them. That's the sentence. One goes in a circle in one's life. That's the sentence that Frank quoted. And so democratic legitimation occurs when I participate in public discourse, defined in the way I've just defined it, and I can come to believe that I have a sense of ownership. This is Bryce's term that we mentioned yesterday, a sense of ownership with respect to the state, that the state is responsive to a public opinion which I've had a part in forming. Now, how do we understand this notion of democratic legitimation? Democratic legitimation turns on what people actually believe. I actually believe that my participation makes a difference, that I have some ownership relationship or some authorship relationship, some kind of connection like that with the state. If I don't believe that, if I don't actually experience that, then the state is not going to have democratic legitimation with respect to me. It turns on the subjective experience of citizens who are participating or not. That's a very important point. Even if we could say philosophically this state should be legitimate, if I don't experience it as legitimate, we don't have the kind of sense of ownership or democratic legitimation that I'm keying the First Amendment to. So the First Amendment exists to protect a subjective relationship of ownership, some subjective relationship that I can be part of the state. And under conditions of modernity, in which the state is quite clearly heterogeneous, in which I'm quite clearly not going to identify with or want a sense of ownership with a lot of the actual decisions which the state is going to make, the best I can hope for is have some sense of ownership or participation in the processes by which we determine what the state will do. That is to say, the processes by which we form public opinion. And that means that First Amendment rights have a particular shape. They protect my ability to have this subjective experience. They protect my ability to participate in public discourse equal to all, but they don't put words in my mouth, because the whole point of my participating is to make the government or make public opinion responsive to me and what I actually believe, and me and my particularity in terms of the intensity of my preferences. And if I'm not permitted to participate in ways adequate to the urgency of my own convictions, then the First Amendment rights will fail to create or protect the potential experience, subjective experience, of participation and ownership. That's why our First Amendment rights have the particular character that they do. They protect my right to use my own words. The state can't put words in my mouth. The state can't compel me to participate in public discourse. The state can't pick my genre. The state can't pick these are inappropriate words or appropriate words for you. My right under the First Amendment is to speak in ways that are adequate to my own sense of the exigencies of the situation. They are subjective. Right? Whereas if the state were to regulate my subjective experience in order to impose an objective standard of equality, I would be alienated from my own words. So if the state were to say to me, everyone gets to write one novel every year, you're writing two, that's too much, that would not be viewed as an appropriate justification under the First Amendment, because it would cut off my urge, my need to write two novels, not one novel. And it's on that basis that equality is not a principle that can be translated easily into the framework of discursive democracy that we developed yesterday. It may be the case that my participation in public discourse is so unequal to others that I experience it as meaningless. If that's the case, there may be grounds for regulation and intervention in order to sustain my sense of meaningful participation. But the ground of intervention in that case would not be equality or lack of equality. The ground of intervention would be the possibility or lack of possibility of a meaningful intervention, and meaningful determined by my own subjective experience. So for these reasons, the notion of equality, I think, is correctly rejected by the court in Buckley as a principle which can justify the regulation of expression within public discourse. So we have a second interest which is put forward in campaign finance reform, and that's known as the Antidistortion Interest. This interest made its first appearance in Supreme Court jurisprudence in 1990 in the case of Austin versus Michigan Chamber of Commerce, in which the court upheld a Michigan statute that prohibited the independent expenditures of corporations using general treasury funds in terms of campaigns for elections for state office. And the court ruled that the legislation was justified, that the state could prohibit independent expenditures by a corporation because of the state's interest in controlling, quote, the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public support for the corporation's political ideas. And the court said This is not an equality interest, it's an anti-distortion interest. So what is the anti-distortion interest? Once again, this is an interest that makes absolutely perfectly good sense in the context of representation. If we're going to have a representation, what should be represented? What should be represented is a transparent and undistorted image of what public opinion actually is. So insofar as we want to have an election, there are criteria for a good election. Those criteria should be some unmediated expression of what the public opinion should be, and that should be our criteria for whether or not the election is doing its job. Is it a transmission belt for a correct and undistorted representation of public opinion as it actually exists? That seems to me a perfectly appropriate principle for a representative system. And the court in Austin says, well, how do corporations fit into this? And the corporation and the court says about corporations, well, elections should represent actual popular support, actual popular opinion. And corporations, because they have this distinct property of being immortal and of being able to accumulate funds in a certain sort of way, don't actually connect to actual public opinion. So the court said the resources in the treasury of a business corporation are not an indication of popular support for the corporation's political ideas. They reflect instead the economically motivated decisions of investors and customers. The availability of these resources may make a corporation a formidable political presence, even though the power of the corporation may be no reflection of the power of its ideas. So roughly, I think what the court's getting at is corporations, because of their legal form, can accumulate funds that are unconnected to the intensity of preferences of real persons. And democracy should always reflect, in its representational phase, should always reflect the preferences of real persons. Corporations don't do that, hence it should be a ground to regulate spending in campaign finance that distorts the expression of preferences in the political system in the context of representation. That's the argument which the court makes. I want to say that from the perspective of the First Amendment, this argument, once again, is problematic. And why is that? Remember yesterday we distinguished between, on the one hand, direct democracy, and on the other hand, discursive democracy. Direct democracy is where you have this direct, unmediated, transparent expression of public opinion, like an initiative or a referendum. And in that context, one would want to have regulations that make the expression of public will as an accurate a picture of public will in terms of our criteria for what public will should be as we can. And so the regulations that are imagined by Austin and the Antidistortion Interest make perfect sense. But we contrasted yesterday direct democracy with discursive democracy. And in discursive democracy, remember, public opinion is never directly represented. There is no representation of public opinion because public opinion is always evolving, and because we said public opinion exerts its influence perennially, constantly, in Bryce's words, but always indirectly. We have to think, someone in government never knows public opinion is this or it's that. They have to interpret what public opinion is. They are, as Bryce said, constantly trying to listen to what public opinion is. He had a very famous sentence, Bryce, the difficulty with government by public opinion is no one knows what it is. And that would be true even if we had a perfect poll of public opinion, because public opinion is always changing from what it was when you polled it. It has nothing you can pin it down to as this versus that. So there is no baseline within discursive democracy from which one can measure distortion. It's just an ongoing process. And just to see what this looks like within the context of First Amendment, imagine my saying to you, you can't write that editorial because you'd be distorting public opinion if you did. What would that look like from the First Amendment point of view? That would mean basically you can't participate in the formation of public opinion. Public opinion is whatever we make it, including what I want to say now. So how can what I want to say now be suppressed on the grounds that it will distort public opinion? It looks more like the freezing of public opinion by what it was before I could participate and make it something else. So that can't be an argument within the context of discursive democracy for suppressing speech. And within political theory, there's a lot of consequences on the notion that public opinion is never directly represented in discursive democracy. The best theorist of that I know of is the French political scientist Claude Lefort, who says in a democracy, as opposed to in a totalitarian state, the place of the people, he says, is always empty. That is to say, we always have to construct what the people are. In a totalitarian society, in what Nadia Urbanati writes, in a populist world, the people have full presence. And then the people get to do what they want with their full presence. A modern theorist of that would be Carl Schmitt, who says the people are present, they have an acclamation, and then we all know what that means. And that's direct democracy, the full, ample presence, material representation of the people. But in discursive democracy, the people's presence is always indirect, which means nothing can speak with that authority. It's always a construction of what the people are. And so the rejection of this anti-distortion interest within discursive democracy, actually a lot's at stake in that. So that's the anti-distortion interest. What about the interest in corruption? Well, if you go and read the cases, actually, this is the most important interest that is used to justify campaign finance regulation. So the state has said you can indeed regulate campaign finances in order to prevent, using the court's phrase, corruption and the appearance of corruption. And the court has even gone so far as to say, quote, preventing corruption or the appearance of corruption are the only legitimate and compelling interests thus far identified for restricting campaign finances. The problem here, of course, is that the court has never been precise about what it means by corruption. We don't really know what corruption is. We have a paradigm case of corruption. That's the quid pro quo. Quid pro quo corruption is I give you, elected official, money, in return you do something for me. And so that's bad. The court has said corruption is a subversion of the political process. Elected officials are influenced to act contrary to their obligations of office by the prospect of financial gain to themselves or infusions of money into their campaigns. The hallmark of corruption is the financial quid pro quo, dollars for political favors. So that's what the court has said is a really important interest. You can't have a system of representation if your representatives are constantly being bribed. So what are we to say about that interest? So the first thing about that interest is it's always put on the table as an interest of the representative system, never as an interest within First Amendment or discursive democracy. And so if you put that interest on the table, the most you can get is a balance between, on the one hand, stopping corruption, and on the other hand, freedom of speech. Because there's no connection, internal connection between corruption, defined in that way, and freedom of speech. Corruption is the need for representative government to maintain true to what it's supposed to do, and we have to stop the corruption of the political process, and we have to balance that need against your ability to speak. And so what you get is balancing, and in part, if you look at the history of campaign finance decisions at the Supreme Court, they balance in different ways, predictably, and you get wide swings within the court of which way they're going to balance, but there's nothing intrinsic to this rationale which tells you how you should balance. That's the first point to make, that we're not dealing with an internal coherent structure, we're dealing with a balance between two competing and extrinsic goods. And in point of fact, the entire structure of campaign finance reform from the beginning has been shaped by this balance. Buckley versus Vallejo, as I said, has set the framework for all subsequent cases when dealing with issues of campaign finance reform. And Buckley versus Vallejo basically says we have to do a compromise between freedom of speech on the one hand and the integrity of the representative system on the other. And we're going to do that compromise by distinguishing between contributions on the one hand and expenditures, independent expenditures on the other. So contributions are when I give the candidate money. So you have a danger of quid pro quo, you have a danger of a bribe, and the court said in those instances your First Amendment rights are minimal, because, I don't know why, but it says your First Amendment rights are minimal, and the needs of the representative system are highest, hence it's compatible with the First Amendment to regulate contributions. But when you're dealing with independent expenditures, I say I'm spending money for the candidate of my choice, but not coordinated, independent, then, says the court in Buckley, your First Amendment interests are at their highest because you're independently speaking, and the dangers of corruption are at their least because they're independent on coordinated expenditures, hence the First Amendment prohibits the regulation of independent expenditures. Remember, when we're dealing with Citizens United, we're dealing with the regulation of independent expenditures. We're on that side of the line. Now, there's a lot to be said about this framework of Buckley, but I think the most important thing is that these distinctions are very hard, in fact, to substantiate in practice. There's a famous article about them very early after by Daniel Ortiz. He calls these distinctions and these reasons large, slow-moving targets, he says. So my First Amendment interest of association is certainly as strong when I'm contributing directly to someone with whom I believe as not. So imagine the state saying, you know what, you can only give $10 a month to the ACLU. You say, wait a minute, they're important to me. They reflect my intensity of preference. Why would it be any difference with respect to a political candidate? And it is also the case on the corruption side that independent expenditures are easily corruptible. That is to say, I know what the candidate wants, I know how to please the candidate, and that I don't need to coordinate particularly to do that. And to give you a recent example that Pam has written about, there was a decision called Caperton, in which you have an elected Supreme Court judge of the state of West Virginia, and there's a party to a case that's about to go up to the Supreme Court, and the party makes vast independent expenditures on behalf of this candidate for the West Virginia Supreme Court, and then the case, and that person wins because it got all this money. The case goes up to the West Virginia court, and the challenge is, well, it's against due process to have that person decide the case because the party has paid for that person to become a judge. And the Supreme Court, as per Justice Kennedy, says, yeah, actually, that is contrary to the appearance of impartiality which due process requires. That person can't sit as a judge. And the distinction between contributions and independent expenditures is so obscure that Kennedy can't get it straight in his opinion, and he constantly refers to these as contributions, even though they're independent expenditures. So this distinction actually doesn't carry a whole lot of empirical or normative weight, but nevertheless, it is the structure within which, since Buckley, we've had to reason through all these problems. So, what then about the interest of corruption and campaign finance reform? The difficulty in articulating this interest is not that it's not a real thing. The difficulty is no one has a strong idea of what corruption is. We have a very strong idea that people shouldn't be bribed, because my obligations as a legislator, as a public official, whatever they are, and we could leave open what they are, they're going to be distorted if I get something in my personal bank account. But let's say the money doesn't go to my personal bank account, it goes to my campaign. We have in this country no public support of elections. That's too bad, but we don't. And therefore, all campaigning happens because of private contributions. It's presumably a good thing if candidates have enough money to run a campaign under our system. So how is that actually a bribe if somebody gives money in my campaign? Well, it's a bribe if I'm unduly responsive. But what does that mean, unduly responsive? And here we have the issue. Judges are supposed to be the mouth of the law. They're supposed to be responsible and accountable only to the law. We might say the same thing about the executive, but what about legislators? We want our legislators to be responsive to their constituents. That's premise one. Responsiveness is an important aspect of democracy. Premise two. We want our legislators to be responsive to those who support them. They want to be responsive to their supporters. That's the way our democracy works. Three, it's perfectly appropriate in this democracy to express your support through money. So what does it mean to be corrupt in that concept? How can you draw the line between appropriate and inappropriate quid pro quo? And in point of fact, we can prosecute bribes, but we almost never prosecute quid pro quo when it goes to the campaign. And even though it would violate the letter of the law in many, many, many ways, you never see these prosecutions, and for good reason, because no one really understands what that line looks like. So corruption is a real interest, but it's very hard to build on it theoretically and to expand it out to campaign finance because it's so controversial at its core what it actually exists, what it actually means. And when the court did attempt to expand it, in a 2003 case called McConnell versus FEC, and this was the case that considered the constitutionality of BICRA overall, the court said, well, the reason why you can regulate a lot of these campaign expenditures has to do with what it called undue influence. It's okay for you to have influence with your representative, but you can't have undue influence. So what's undue influence? And of course, the court has no account of that. There's not an account that goes out of the role of a representative when you're being too responsive to a constituent. There's no account of that. And if you actually were to press the court on that, you would get an explanation, I'm guessing, because no one presses them, but if you were to press them, it would be undue influence when, as a system, as a property of the system of representation, wealth has too much influence, it's unequal, or it's a distortion in terms of its response to what public opinion actually is. In other words, the only way that I can think of to cash out the notion of undue influence is to go back to the principles which you've already said cannot be used consistent with the premises of the discursive democracy which the First Amendment is designed to protect. And so while we have this interest in suppressing corruption, we do not have an account of corruption that can be generalized in a way that's very helpful to us. And for that reason, the court has been quite hostile, I think appropriately hostile, to expanding it too much without an account of what it is. So then, now, where does that leave us? So this is I'm repeating dressed up, sort of, this is what Citizens United says about the interests which are put on the table to support BICRA's prohibition of independent expenditures by corporations. And the court says, well, those aren't compelling interests. Not only there's not compelling interests, those are interests that are inconsistent with basic premises of First Amendment doctrine and jurisprudence, so we have to strike this down. So what I'm going to do now is attempt to give you an account of what a compelling interest, constitutionally speaking, might be. And this account actually goes right back to, once again, what Frank was saying at the outset. So if we think about discursive democracy, we say we want to protect it because it embodies the value of democratic self-governance. How does it do that? I participate in public opinion, and I have the trust and belief that public opinion is responsive to, that the state is responsive to public opinion. Right? There's two propositions there. One is my freedom to participate, and the second is the notion that the state is responsive to public opinion. So now query, what underwrites the second premise? How do we know? How do we ensure that the state is responsive to public opinion? How do we know that? And it turns out that the only answer we have is elections. Right? This is not a notion of elections as representative. This is a notion of elections under the sign of discursive democracy, elections as an institution which is designed to tie government and elected officials to public opinion. Right? And once we say that, then we can say, are elections structured in a way, are they structured in a way that allows the public to have trust and confidence that the elections will produce officials who are responsive to public opinion? That's a coherent question within the very framework of discursive democracy, which the majority opinion in Citizens United purports to be unfolding. Are elections structured in a way that the public can have trust and confidence that elected officials are responsive to public opinion? I am now going to use the words electoral integrity to describe that property of elections. We can ask whether elections have electoral integrity. And notice that if elections do not have electoral integrity, then the link between public discourse and self-government is broken. Because I can talk all I want, and if nobody is listening, there's no democratic legitimation at all. We have to presuppose, there has to be faith, there has to be trust that people are listening to what I'm saying, or the whole system of democratic legitimation does not get off the ground. Now, does it imply from this concept of electoral integrity that representative officials must be, in Hannah Pitkin's language, delegates or agents, as opposed to something else? Are we back to Jacksonian democracy, where we say it's the job of the representative to obey public opinion? And the answer is no. And the reason the answer is no is because in this context, we're imagining public opinion in the shape of discursive democracy and not direct democracy. And this is an extremely important difference. In direct democracy, public opinion can be represented. It can have a definite content. We know its content because we have an election and we have an initiative. Within discursive democracy, public opinion is never represented. Its influence is always indirect. And that means when representatives are in touch with public opinion, they're in touch with something that they're not only helping to construct, but having to make a judgment about what it is. And what one has is a relationship, a dialectical relationship between the representatives and the construction of public opinion that cannot be captured in anything so simple as a principal-agent relationship. I think Hannah Pitkin is exactly right when she talks about political representation. She says, none of the analogies of acting for others on the individual level seems satisfactory for explaining the relationship between a political representative and his constituents. He is neither agent, nor trustee, nor deputy, nor commissioner. And notice that this property of electoral integrity is not something that describes individual actions by a representative. It's a property of the system of representation that we have. We say the system has this electoral integrity, or it doesn't, because it goes to the public trust in whether elections are structured in a way that produces this property. So we can say, as a constitutional principle derived from the very discursive democracy and First Amendment rights that Kennedy and the 5 justices who are in the majority in Citizens United affirm, that there is a requirement that elections be structured so as to maintain and sustain the property of electoral integrity. And maybe campaign finance reform can be justified in this way. Now notice, if we were to reformulate the argument in this way, we have potentially common ground between the dissent and the majority in Citizens United. The majority believes in First Amendment rights. It believes in First Amendment rights because it's necessary for self-governance. But it's only connected to self-governance if there's electoral integrity. And similarly, the dissent believes in the integrity of electoral institutions. And that integrity is in part measured by this notion of responsiveness to public opinion and faith in that responsiveness. Now, I'm not going to say this is going to settle the controversy. All I want to say to you is, once the present partisan controversy settles out and the dust settles and people can think clearly, maybe in a generation, this is a principle on which all parties can agree. We can all say we have to be committed to this principle if we care about democratic legitimation. So it creates the possibility for reconstructing constitutionally the landscape of campaign finance reform. And I want to say, this is not a principle that's utterly foreign to the court. We see references to it in Buckley itself, which talks about the need to preserve confidence in the system of representative government. The closest I've seen the court actually stay what I'm saying now is in a case called Nixon versus Shrink, Missouri, where the court observes, per Justice Souter, that, quote, the cynical assumption that large donors call the tune could jeopardize the willingness of voters to take part in democratic governance. Democracy works only if the people have faith in those who govern. So there are hints, there are little sentences which go here, but they always, in the Supreme Court's opinions, go back to notions of corruption, or notions of distortion, or notions of equality, which make sense within a system of representation, but not within a system of a discursive democracy. And if one were to look at the court's opinion in Citizens United, you see something like a gesture toward this notion, and then the court says about the concept of electoral integrity, I'm translating it now, it doesn't use those words, it doesn't really have a clear grasp of that concept, but something like that, the court says, well, that's a question of law, not of fact. So someone objects in Citizens United to the idea that corporate expenditures, unregulated, might cause a loss of faith or trust in the system of representation in elections, and the court swats that objection aside, and it says this, I'm quoting the court now, the appearance of influence or access, furthermore, will not cause the electorate to lose faith in our democracy. By definition, look at this language, by definition, an independent expenditure is political speech presented to the electorate that is not coordinated with the candidate. The fact that a corporation or any other speaker is willing to spend money to try to persuade voters presupposes that the people have the ultimate influence over elected officials. This is inconsistent with any suggestion that the electorate will refuse to take part in democratic governance because of additional political speech made by a corporation or any other speaker. That's what the court does with the closest it gets to this idea of electoral integrity. So to that, one might say this, the American people have worried since the Progressive Era, the statutes that I mentioned to you yesterday, since the Progressive Era, that unlimited corporate expenditures might actually make representatives lose touch with public opinion. And that worry, that belief has had legislative enactment for over a century. It's been a long-standing democratically enacted judgment of the American people that this is a problem, a potential problem. And it seems to me that it is the height of hubris for a court, by a vote of 5 justices to 4, simply to dismiss concerns for electoral integrity on the ground that electoral integrity is a question of law, not of fact. That seems to me the height of hubris. The point that I stressed to you yesterday, that Madison and Brutus agreed upon, what they agreed in the middle of their debate was that electoral integrity depends upon contingent empirical facts and institutional structures. That's why they're debating the structure of the Constitution in 1789. Because the faith of the people in the representative integrity of their institutions depends upon their structure, including who can spend in elections. That it is a matter of fact has been the lesson of American politics that I went over in history yesterday. And it is certainly the case that if Americans lose faith in the electoral integrity of their representative system, that faith cannot be restored by the professional legal assertions of a Supreme Court, especially in the context of a divisive and politically controversial opinion. That's not going to make people believe in trusting that their representatives are listening to them. And that's because, like democratic legitimation, we're all founding this, electoral integrity depends on what people actually believe. You know? Now, we had a recent example of how dramatically the court is out of touch with this construction of campaign finance reform. In 2 years after they decided Citizens United, a case came to the Supreme Court from Montana as a petition for certiorari for review. And Montana had a law which was enacted in 1912, and that law was enacted in response to a manifest loss of electoral integrity in the state of Montana. And that's because Montana is a state in which there are large corporations of agricultural and mining interests, which basically bought the state. And the state was in a state of despair. As one Montana newspaper said at the time, if the Copper Trust must rule Montana, why not cut out all pretense of a representative government and haul down the flag of a free state? Why not abolish the legislature and dispense with the state government? It's under those sorts of conditions, and the facts of this brief are, they pay the legislators get up and they say on the floor of the State House, well, the Copper Trust told me to say such and such, so I'm going to say such, and there's just no doubt about it. And so Montana Supreme Court had said, in this context, of course, electoral integrity should be a justification for campaign finance reform, for prohibiting corporations from talking. And what did the Supreme Court do? It granted certiorari, and it reversed summarily without even hearing the facts. Why didn't it hear the facts? Because the facts aren't relevant. Because it's a holding of law, says the court, that electoral integrity cannot be affected by corporate expenditures. So I just want to say, it's beyond my comprehension how a court might regard electoral integrity as irrelevant to the protection of First Amendment rights, and how it might regard history as irrelevant to the precious resource of electoral integrity. I simply don't understand how the court can say that. Electoral integrity has to be regarded as foundational for American democracy. And not only is it consistent with First Amendment jurisprudence, if the argument I put on the table is correct, it's required by First Amendment jurisprudence. And I don't think anyone could argue that electoral integrity today isn't under threat. If you look at the various polls, 69% of the American public in 2008 say government is pretty much run by the big interests and so forth. One can find polls like this. I don't want to say that electoral integrity is a matter of polls. In fact, I don't believe it, but it's certainly relevant to know the facts, and certainly worth an argument before the Supreme Court about whether under these state of the facts, electoral integrity is at stake. But the court ruled it out as a matter of law, and thus showed itself to be completely uncomprehending about the compelling interest under the First Amendment, consistent with discursive democracy, that campaign finance reform might depend upon, might summon in defense of its own provisions. So that's point one. Point two, as I say, the opinion in Citizens United is not a model of clarity, very hard to know what it's actually saying and not saying, but there's a second ground on which they strike down the law in BICRA that we're considering. And the court's reasoning here is as follows. There is a fundamental First Amendment rule that the state can't distinguish between speakers. It can't pass a law that says Speaker A can talk but not Speaker B, corporations but not people. And because there is this law, because it discriminates on the basis of Speaker, it's subject to strict scrutiny, and therefore it's unconstitutional. So the court here is depending for its argument on the notion of a First Amendment rule that prohibits what's called speaker discrimination. Now, it's easy enough to imagine the paradigm case from which the court is deriving this rule against speaker discrimination. So if we are speaking in a newspaper, the state can't pass a law that says Republicans can speak but Democrats can't. Why is that? That rule exists because everybody should have, as I said at the beginning, equal right to access to public discourse. But is that a general rule of the First Amendment? And the answer is no. Just to give you a very simple example, Speaker A gives you legal advice. Speaker B gives you exactly the same legal advice. Speaker A has a license to practice law. Speaker B doesn't. Speaker B gets put into jail, and there's no First Amendment issue whatever. That's unauthorized practice of law. There's no First Amendment issue. We discriminate between speakers all the time outside of the context of public discourse, right? So what does that tell you? That tells you you get a rule, you generalize the rule, but you mistake the rule when you generalize it to circumstances to which it has no application. The application of that rule is everyone has an equal right to public discourse. So is that the issue in Citizens United? Is the issue in Citizens United access to public discourse? So how do we analyze that question? So we start with the premise: why do we have public discourse? Democratic legitimation. What's the point of democratic legitimation? The subjective apprehension of autonomy or responsiveness of the government. So imagine this. Imagine there was a viral communication that replicates itself throughout the internet, and someone tried to stop it. Does the viral communication have a First Amendment right to continue on reproducing itself? You would say no. Why would you say no? Because a viral communication can't experience democratic legitimation. It's a thing, not a person. And therefore, the reason you protect the rights aren't present for that viral communication. So at issue in Citizens United are what? The speech rights of corporations. Corporations are things. They are not persons. They do not have the subjective experience. They cannot experience democratic legitimation. That's why, for example, corporations don't vote and they don't sit in legislatures, because they can't experience subjectively the forms of democratic legitimation which are the foundation of the First Amendment rights that we have been considering. Now, that doesn't end the argument, because, of course, corporations can assert the rights of others, of real persons. They can do it in at least two ways. One way, it can assert the rights of persons who make up the corporation, or it can assert the rights of persons who are strangers to the corporation. So let's take each of those. Can the corporation assert the rights of people who are part of the corporation, make it up? So First Amendment theory, doctrine, has a well worked out doctrine about when it is that groups can assert the rights of members of the groups, the First Amendment members of their groups. There is no inherent First Amendment right to associate. I have no First Amendment right to form a corporation. But there is a First Amendment right to associate for the purpose of exercising First Amendment rights. And we call such groups in the doctrine expressive associations. So I have a First Amendment right to form an expressive association, like a political party, that expresses my point of view. And when we have formed such an expressive association, that association can assert all the First Amendment rights of the members of that association. That's standard First Amendment doctrine. And that is actually true also in the realm of campaign finance reform. So in a very famous case, FEC versus Massachusetts Citizens for Life, we had a group that was an expressive association formed to be anti-abortion. Now, it formed itself for this purpose. It took a corporate form. And as a corporate form, it was, under the previous law, prohibited from having independent expenditures, but the Supreme Court said, but actually, it's an expressive association. And the fact that it assumes a corporate form doesn't strip it of that constitutional status, and therefore, you can't apply the ban on corporate expenditures to this group, because this group is an expressive association whether or not it's a corporation. Well, most corporations, and certainly the kind of corporations that are mostly governed by the provisions in BICRA that we're talking about, are not expressive associations. They are ordinary commercial organizations, and they're made up to have profits, not to engage in First Amendment rights. And Justice Scalia himself has written this, The robust First Amendment freedom to associate belongs only to groups engaged in expressive association. The Campbell Soup Company, for example, does not exist to promote a message, and there is only minimal constitutional protection of the freedom of commercial association. Now, this is not a trivial point, because if the First Amendment were to govern my ability to get together in a commercial associations, all of corporate law would be a First Amendment problem. Every regulation of my ability to associate in ordinary commercial associations would be a First Amendment problem. And notice, we regularly regulate the speech of commercial associations. We require them to have factual disclosures, to speak, and to disclose certain things which we could never do to ordinary persons. So this is a very important distinction, and under standard First Amendment doctrine, which I don't think anyone would want to contest, the corporation has no right to speak in its own name as representative of the membership of the corporation, because it's not an expressive association. So what about the First Amendment rights of others, of strangers to the corporation? Well, in point of fact, the first Supreme Court case to really address this issue of the speech of corporations turned its reasoning exactly on this point. This is the case, it's called Bellotti, First National Bank of Boston versus Bellotti, that Kennedy purported to rely on in Citizens United, and the court was extremely careful to define what it meant when it said corporations had free speech rights in Bellotti. So I'll read you the passage. This is Powell speaking for the court. The court below framed the principal question in this case as whether and to what extent corporations have First Amendment rights. We believe that the court posed the wrong question. This is the decision on which Citizens United is relying. We believed that the court posed the wrong question. The Constitution often protects interests broader than those of the party seeking their vindication. The First Amendment in particular serves significant societal interests. The proper question, therefore, is not whether corporations have First Amendment rights, and if so, whether they are coextensive with those of natural persons. Instead, the question must be whether the statute at issue in this case abridges expression that the First Amendment was meant to protect. So the question is not the corporation in its own name having First Amendment rights. The issue is whether we protect the expressive activities of the corporation in order to protect, say, those who receive the communication of the corporation. And this was a case involving a Massachusetts statute that prohibited independent expenditures in election referenda from corporations. And the court, in saying that that statute was unconstitutional, invoked the First Amendment theory of Alexander Meiklejohn, who said, we have First Amendment rights not for the speaker. Now notice I've been giving you a speaker-oriented account of First Amendment rights. We protect First Amendment rights not for the speaker, but for the listener. It's because we have a right to receive information that we protect freedom of speech in a democracy. And so the court in Bellotti rules, yes, the corporation can speak because the information it's wanting to disclose is, quote, indispensable to decision-making in a democracy, that is, indispensable to the voters who receive that information. And the court reasoned that the inherent worth of the speech, it's quoting it now, in terms of its capacity for informing the public, does not depend on the identity of its source, whether corporation, association, union, or individual. Now, that's a coherent form of reasoning. It's saying this is a corporate entity. It wants to disclose information to the public. The public has an interest in receiving information. So there's a First Amendment issue when you cut off that circulation of information. But notice that Bellotti, in this case, is quite carefully saying, as explicitly as it's possible to be explicit, the rights of a corporation are different than the rights of a person. You and I have a right to participate in public discourse because for you and I to participate, democratic legitimation is at stake. But democratic legitimation is not at stake for a corporation. The only thing at issue for the corporation is the receipt of information which the corporation wants to disclose on the part of voters or the general public. And these are very different kinds of rights, completely different kinds of rights. So just to give a simple example, because the First Amendment right of democratic legitimation refers to my subjective experience, you can't compel me to speak in public discourse. Right? But we can compel corporations to speak, because they have no democratic legitimation that's at stake. They have only the informational rights of the audience. So if I compel them to give information, I've added to the informational stock of voters. So it's a different kind of right there. Or what's at stake in democratic legitimation is what Brandeis called the supremely precious idea that as a citizen, you're making the government better. You are participating in the government. And we don't want to chill that at all. And if the state's going to interfere with that, that's a big deal. Because it's hard enough to get citizens to be Republican, that is to participate in the common good, to speak to each other about public matters. And anytime the state even chills that, that's a very bad idea. And so to stop that, the state needs a compelling interest. But in First Amendment doctrine, when all you have at stake is the communication of information, which is, say, our regulation of commercial speech, just for example, there are lots of interests which can impede or regulate just the communication of information. And so you may not need a compelling interest, because democratic legitimation, which is the most important aspect of the state, is not really the issue anymore. The issue is only, is this information communicated? It could be communicated in many ways, in many different contexts. So we regulate commercial speech now without requiring a compelling interest, because the democratic legitimation is not at stake. Or there's a whole branch of First Amendment doctrine which is very well developed. It's called chilling effect analysis. So if the state acts in a way that casts a chill on your participation, that's very bad. Right? Well, we don't use chilling effect in commercial speech because all that's at stake is the receipt of information. Now, the court and Citizens United does not have a grasp of this difference. Its argument is corporations are like people. We use the same First Amendment regulation that we do for people, that we do apply that same standards to corporations. That's not right. The constitutional question posed by BICRA, by the provision that we're considering, is, does it decrease the amount of information that the public receives? Because that's the constitutional value. The constitutional value is not democratic legitimation. The constitutional value is the receipt of information. And actually what the law provided was not that corporations couldn't speak, but they had to speak in a particular way through what's called a PAC, a political action committee. And if the members of the corporation who wanted to speak wanted to use the apparatus of the corporation to make a PAC, they could do so, they could contribute, and then they could say what they had to say through this apparatus of the PAC. And Kennedy says for the court, well, it's very chilling, it's very difficult to make a PAC, and therefore it's a bad thing. It's as if you stop the speech using the chilling effect analysis. But that's not the issue. The issue, the precise constitutional issue is, would you have less information if you required the corporation to speak through a PAC than if the corporation could speak directly? That's an empirical question. And nothing in the court is focused on that empirical question or looking at the evidence one way or another. And in point of fact, what makes this interesting is if you look at situations where we actually want to get information across to the public, where it's really important to have informed decision-making, which, as Bellotti says, is the issue when we're dealing with corporate speakers, which can't experience themselves democratic legitimation. In such situations, what do? We do not say a free-for-all. If I'm a court and I want to have informed decision-making by a jury, I have a very structured process which channels and regulates the flow of information to the jury. If I am the legislature, Congress, and I want to have informed decision-making on a bill, I have hearings, I have debate, all carefully structured to maximize information flow and the quality of information. If I'm in a classroom in a public university and I want to maximize information to my students, do I say anyone can talk who wants to talk for as long as you want because you have the resources to talk? No. I make judgments about what's more informative and less informative. And so in situations in this culture where we actually care about informed decision-making, laissez-faire turns out to be a very disfavored alternative. And this actually has roots which also go back to the progressive era. If you look at the time, if you look at the first decades of the 20th century when public opinion emerges as the site of democratic sovereignty, simultaneously with that focus on public opinion, you have emerging, as you would, a critique of public opinion. And here think of 1922 and Walter Lippmann's book, Public Opinion, in which he says, public opinion is so easily manipulated, it's unreliable, and it cannot be the basis for democratic legitimation. So Walter Lippmann sees that. In The Phantom Public, he takes it further, but he's not willing to say, well, therefore we have a government of experts. What he says is, well, we need, therefore, institutions to educate the public. And we need kind of Michelsonian structures in which information is carefully channeled and the public can be educated well. That's the solution to informed public decision-making, not laissez-faire, if you cared about that. And so that raises a whole set of empirical problems about whether or not the question is, does public decision-making become less or more informed once one strikes down this provision of BICRA. It's not something you can answer by abstract doctrine. But the court proceeds as if this was a simple question of the regulation of public discourse, which it most definitely is not. So just to summarize my argument, I think I've gone on too long. What have we said about Citizens United? Citizens United begins with the premise that Section 441B regulates public discourse and therefore must receive strict scrutiny. It finds it without compelling justification and therefore unconstitutional. So if the arguments that I've advanced so far are correct, this whole framework of analysis is wrong. First, and most importantly, the court fails to acknowledge the fundamental significance of electoral integrity as a justification for the regulation of campaign finance expenditures. Electoral integrity is necessary for the very First Amendment rights that the court in Citizens United wants to protect. Second, to the extent that the court does glimpse an interest in electoral integrity, it falsely imagines it as a matter of law rather than as a matter of fact. Electoral integrity is contingent upon systems of electoral design and structure. We know this, we have seen it come, and we have seen it go. History in the United States, governments have continuously altered electoral structures to maintain this resource, this very precious resource of electoral integrity. Third, the court writes as if BICRA regulates public discourse, but it actually doesn't regulate public discourse. It doesn't regulate the speech of natural persons. It doesn't regulate forms of communication which raise the issue of democratic legitimation. If, for example, the speech, Brandeis says, the danger of state regulation of speech is that we become an inert people. That's his language, an inert people. If corporations are, commercial corporations, I'm only talking about ordinary commercial corporations, are prohibited from speaking, we don't become an inert people. The question of becoming an inert people or not is not raised in this case. Instead, we have an issue of the transmission of information to the public. And as such, as in other contexts where the only issue is the transmission of information, we have a context in which strict scrutiny is inappropriate. Fourth, it is an empirical question whether Section 441B actually diminishes the flow of information, useful information to the public, or whether that flow of information could be better regulated by very common forms of regulation, like in a court or in a legislative hearing, that does discriminate between persons and that controls the flow of information. And fifth, let's suppose that the BICRA provision actually does diminish the flow of information to the public. In such a situation, the court would have to balance the diminished information to the public against gains to electoral integrity caused by BICRA. So there's going to be some kind of constitutional trade-off between, on the one hand, the constitutional good of electoral integrity, and on the other hand, the diminished flow of information to the public. And that kind of trade-off would be necessary to a constitutional decision because electoral integrity is of the utmost importance. Confidence of the people in the electoral integrity is of the utmost importance in our system. Now, in such situations, when the state regulates to preserve deep and important First Amendment values, in a case like Turner Broadcasting Systems versus FCC, for example, the court has said in such cases where there is content-neutral regulation in support of an important First Amendment end, we will defer to congressional findings. I don't want to say absolutely deference is necessary here, but I do want to say in this context, the issue is one of electoral integrity. Electoral integrity turns on the trust and confidence of the American people in the fact that elections are producing officials who are responsive to public opinion, and this is not at root a legal question. This is a judgment of political legitimacy of the deepest sort about whether the integrity and legitimacy of our institutions are at risk. And I think any looking at the polling now indicates we are at risk. And who is best entitled to make a judgment like that? Is that a judgment that should be entrusted to a court which is insulated from politics, or to politicians themselves? Now, it is said, John Manning said yesterday, I think appropriately, you have reasons to distrust a Congress that is regulating the system of elections that has produced them. And any system of regulation of campaign finance must be scrutinized for the danger that it's, as Scalia always wants to say, an incumbents protection bill. And that's a danger. But the fact that that's a danger doesn't take away the other dangers which are present, the danger of the loss of electoral integrity. And there's no justification for the court shutting its eyes to that danger because Congress may be merely self-serving. The appropriate response to that is a court should be aware of both dangers and do its best to mediate between them. That's what follows from that danger. Now, I would say that when I have talked to people about these ideas in the past, what I find is that those who oppose campaign finance reform say, yeah, but if you actually make campaign finance reform depend upon something as ethereal, as interpretive, as judgmental, as whether electoral integrity is at stake, you're basically giving a blank check to Congress to do anything. And so we can't second guess it. There would be a loss of judicial control over the regulations. And in such situations, better do nothing. That, I think, is the brunt of many objections I've heard to this proposal. And I think it's going to be difficult to make these judgments. And in these lectures, I am not taking any position about any of the empirical propositions I put before you. I'm not saying electoral integrity is at risk. I'm not saying it could be repaired by campaign finance reform. I'm simply saying this is the framework of constitutional analysis we ought to adopt when we see these efforts to regulate campaign finance expenditures. And it will be difficult to make a record that will justify or not justify the attempt to regulate campaign finance. But what I want to say is courts can be alert to the danger of the loss of electoral integrity without losing a total grip on the control of the campaign finance system. And there are instances where it is simply undeniable that electoral integrity has been lost. And I adduce as my example, and I'll sit on this example, the case in Montana. You know, Montana, if you read the Supreme Court of Montana's opinion, there is no way that you come away from that opinion without concluding, actually, in Montana in 1909, electoral integrity was seriously at risk, and the state acted to save that resource. And if you have one such case, then we can begin to talk about how much more we need. And all I need for my argument is there is undeniably one such case, and the Supreme Court of the United States turned its back on it in the name of a set of First Amendment formalisms which really put our democracy at risk. And it's that thought that I want to leave you with. I'll stop there.
So among the many issues that the framers struggled over was the question of how to select the president. The idea of national popular vote was both fanciful and terrifying, so quickly the idea of a convention was fixed upon, an electoral college convention. But what if the college was tied? Who should resolve the deadlock? Some suggested the Senate, but that idea was quickly rejected. And it is the argument for that rejection that I'd like you to focus upon here, as summarized by Zachary Brugman. Quote, referring the appointment to the Senate lays a certain foundation for corruption and aristocracy, noted Hugh Williamson from North Carolina. Quote, the aristocratic complexion proceeds from the change in the mode of appointing the president, which makes him dependent upon the Senate. George Mason similarly asserted this dependence on the Senate, while there was simultaneous indirect dependence upon the people, would, quote, subvert the Constitution. He would, quote, prefer the government of Prussia to one which will put all power into the hands of 7 or 8 men and fix an aristocracy worse than absolute monarchy. James Wilson agreed. Because of his, quote, dependence on them, the Senate, the president will not be the man of the people he ought to be. He would be a, quote, minion of the Senate. The dependent relationship posed, quote, a dangerous tendency to aristocracy. Now, to a modern, like most of us are, this use of the word corruption is strange. The tendency towards aristocracy is clear enough, but wherein is the corruption? As we use the term, our minds are likely to race to the idea that a candidate for president might, in the circumstance of the Senate selection, be tempted to buy off a few senators. But that is not the sense in which the framers meant the word. It's rather Wilson's usage that is most salient here. This, quote, dependence on them, the Senate, will mean that the president will not be the man of the people as he ought to be. The corruption, in other words, follows from an improper dependence, or more precisely, from the mere chance of an improper dependence if indeed the Electoral College were to tie. Now, as a longtime student of the work of Robert Post, I am quite certain that he has cracked the question of campaign finance reform. I'm just not certain he has done so in these Tanner lectures, or at least not completely. That is, I'm certain that his method and approach to the First Amendment gives us the tools to see just how the Supreme Court has gone wrong in its campaign finance jurisprudence. But I fear that in these lectures, a key Postian move has been left on the cutting room floor because of a confusion about this word, quote, corruption. And in my response, I'd like to re-edit the argument a bit to include this critical outtake and restored pride of place to this central idea, or at least central to those of us at the Safra Center, institutional corruption. Now, you should believe me in this, because in making this argument, I'm speaking against interest. It is the highest honor to be a character in a Tanner lecture, and in the written version of this lecture, I am a character. Yet what I'm about to say is certain to assure that I get removed from the permanent records of this lecture. So you should recognize that if I'm willing to risk that to make this point, that means, in the only currency relevant to the Academy, I am willing to put my money where my mouth is. Post describes in the written version of this lecture my work as an example of work criticizing the system of campaign finance for the, quote, distortion it produces within our political system. But mine is not a distortion theory of campaign finance. Mine is a corruption theory. For if we understand corruption properly, it would be obvious why Congress should have the power to regulate even speech to control it, and easy to see how that regulation of it is essential to representative or electoral integrity. But Post punts on defining corruption because practically everyone in the Academy has punted on the task of defining corruption. In his longest footnote in his incredibly well-documented article, Post summarizes the scholarship struggling to understand what, quote, corruption means, and then displaying the sort of humility that is his nature, his note almost screams, if these smart people can't figure this out, why should I expect that I could? But here at Harvard, we don't suffer this sin of humility. And so we're not as likely to be stopped merely because everyone else has, and neither should Post have stopped. For his humility notwithstanding, it is Post's own theory, tied to his rich sense of history, that should cut the Gordian knot of corruption confusion. For here is the most striking fact about the Supreme Court's campaign finance jurisprudence, that its core holding, that Congress may restrict speech that is or gives a reasonable appearance of quid pro quo corruption, has no solid theoretical grounding. Think about it. Why is it that Congress has the power to ban quid pro quo corruption, let alone the appearance of quid pro quo corruption? After the court affirmed that power in Buckley versus Vallejo, it didn't take long for scholars to tease apart the incompleteness in that incompletely theorized agreement. David Strauss did it most effectively and most clearly. There are two types of quid pro quos that might constitute this corruption, one to benefit a member personally and one to benefit a member politically. The former we call bribery. The latter we, or at least Chicagoans like David Strauss and Rob Blagojevich, call politics. So to put the bribery issue aside for a bit and compare two hypothetical statements, one by Drew Faust, Harvard's president, and one by Bill Yeager, Harvard's director of the almost 5,000-person clerical and technical union. Imagine President Faust said to a member of Congress, "If you promise to secure an earmark for Harvard, I promise to contribute $5,000 to your campaign." And imagine Director Yeager said to the same member of Congress, "If you promise to secure an earmark for Harvard, I promise to guarantee 5,000 votes in your election." Now, under American law, a member of Congress who agreed with the plan Faust hypothetically, let me emphasize that, hypothetically proposed, would have committed a felony. But under American law, a member of Congress who agreed with the plan Yeager hypothetically proposed would have been engaging in simple politics. But why the difference? For after all, as Strauss and others have noted, the only purpose of the $5,000 contribution is to fund speech designed to persuade people to vote. So why is doing something in 2 steps a crime when doing the same thing in 1 step is not? This is a puzzle. But it's a puzzle for the court. For the implications of this one clear paradigmatic case are in tension with the court's other First Amendment commitments. That was Strauss's point. In Arizona Free Enterprise, for example, the court seemed to embrace as a foundational principle the idea that any reform designed to, quote, level the playing field violates the First Amendment. But obviously, to ban quid pro quo corruption is to level the playing field. In a kleptocracy, the rich have more power than the poor. To ban bribes or quid pro quo corruption in a kleptocracy is thus to level the playing field of the rich and the poor. So why is that leveling permitted under the court's jurisprudence, but the leveling of Arizona's public funding system not? Now, I'm not arguing that the court couldn't offer a response. Dennis Thompson's work is a clue to that response, but even he doesn't think the matter is simple. My point instead is that any such response would be contestable. It would hang upon a particular theory of representative government, and as Post showed us yesterday, such theories prevail and then they change, they evolve. And what all that contingency should drive us to ask is whether there isn't, for an originalist at least, a more stable or historically solid conception of corruption that might more reliably guide the court in its protection of representative or electoral integrity. And here we should turn back to the corruption of the presidency that I opened this comment with. For what Wilson and Madison and Mason were doing in that passage, in particular, and in their language more generally, was evincing a conception of corruption different from the conception we moderns use. A conception that predicates of institutions or of societies or of whole peoples, a collective conception as distinct from our more modern sense of corruption, which typically predicates of an individual alone. As Lisa Hill described, quote, "Until the end of the 18th century, corruption had a much broader meaning than it does today. It referred less to the actions of individuals than to the general moral health of the body politic." Now, as applied to an institution, no doubt there are plenty of difficult and contestable questions here as well. Again, Dennis's work is most illuminating in the context of Congress. But the one clear, in a Rubenfeldian sense, paradigmatic case, at least for the framers, is an institution that evolves an improper dependence. In the Newtonian world of the framers' design, the institutions were properly independent only when those institutions were secured by a proper dependence. For the non-lawyers, think James Madison channeling Jane Austen. The framers designed an independent judiciary, meaning one that was supposed to be, quote, dependent upon the law and not upon Congress or upon the president. The framers intended the president to be, quote, independent, which meant dependent upon the people and not upon the courts, or, as the initial passage emphasizes, upon the Senate. For them, the core of representation was not just choice and a commonality of interests, as Post described yesterday. It was also the mechanism of dependence that would secure over time the communication of interests that the Republic was to secure. And so too with Congress. Congress was to be independent, which, as Madison described, meant dependent upon the people and not, for example, upon the president, as Parliament had been dependent upon the king. And not just dependent upon the people, but as Federalist 52 puts it, dependent upon the people alone, an exclusive dependence, which would be corrupted if another inconsistent dependency were allowed to evolve within the economy of influence that is Congress. Now, I submit that if the framers would have thought that the mere chance of the Senate's resolving a tie of the Electoral College would, quote, corrupt the presidency, then a fortiori, a system in which Congress is dependent upon the tiniest slice of us, less than 0.05% of us, our own aristocracy, for campaign funds would also and plainly have been corrupt for them. That from their perspective, it isn't quid pro quo corruption that's the easiest and obvious case. It is dependence corruption that is the easiest and obvious case. Or to put it more strongly, the core for us is their periphery, and the periphery for us would have been their core. And only a non-originalist, which none of the 5 justices in the majority of the Citizens United decision would confess to being, could believe that only quid pro quos could be the kind of, quote, corruption that would provide a compelling state interest to protect representative or electoral integrity. So how does this help Post, who would never bind himself to anything as crude as originalism? Well, when you view corruption in this way, it begs for a distinction that I was certain would be at the center of these Tanner lectures, given everything Post has written before. A distinction between regulating speech intended for public discourse, or as I'll call it, for the public domain, and regulating speech intended to affect the government. These are 2 radically different constitutional domains. And while the First Amendment properly forbids the government from managing speech intended for the public domain, the First Amendment differently limits the government from managing speech affecting its own constitutional domain. That is the difference between regulating corruption and regulating independent expenditures. An independent expenditure is speech meant for the public domain. Its purpose is to affect us, the citizens, and it's not the government's job to protect us citizens from the effect of such speech, whether the government likes it or not, or whether the government thinks its effect is properly earned or not. But speech manifesting corruption is speech targeted at a government official. The offer of a bribe is not intended for 60 minutes, and the intercourse between candidates and their funders is not speech meant to facilitate democratic deliberation. Just ask Mitt Romney whether he intended his 47% comment to be sprayed across the YouTube domain. It is instead speech intended to affect the chain of representation between the candidate and the funder. But from the framer's perspective, that means it is speech intended to corrupt the chain of representation if it manifests a dependence different from the dependence upon the people alone. Let's call the domain targeted by corruption regulation, then, the republic domain. Within it are all the regulations necessary to preserve the representative or electoral integrity of a republic. And so understood, following Fred Schauer, while the First Amendment certainly covers speech within the republic domain, it doesn't protect it in the same way it protects speech within the public domain. And if we distinguish between this public domain and the republic domain, then it's clear why Professor Kagan was right that Austin versus Michigan Chamber of Commerce was wrong. In that case, the court upheld a regulation on corporate speech, but corporate speech intended for the public domain. The government shouldn't have that power, Kagan believed, to protect us from disfavored speech, regardless of its source. That's why independent expenditures are protected, at least for individuals, as Buckley holds, and possibly also for corporations, as Citizens United hold. But that conclusion says nothing about the regulations that should be permitted within the republic domain. We can ban speech within that domain by regulating secrets. We can prohibit speech on the basis of content by regulating bribes or quid pro quo corruptions. And we should be able to regulate dependencies of corruption within that domain, or again, dependencies which manifest this improper dependence. So how would such a move matter to current campaign finance jurisprudence? Well, again, the precise holding of independent expenditures in Citizens United stands, as does Buckley. The government can't regulate speech within the public domain. Likewise, with the limits on contributions in Buckley stand, those are regulations within the republic domain, targeting government officials or government wannabes by regulating quid pro quo corruption or its appearance. But Buckley can't justify aggregate limits on campaign contributions, the issue the court will consider this fall in a case called McCutcheon. Yet dependence corruption could remove aggregate limits, as the court in Montana clearly suggested, and you shrink even further the number of funders in an election and therefore increase the improper dependence in the election. And Buckley likewise couldn't justify limitations on contributions to independent political action committees, the issues that the DC Circuit decided in Speech Now, which triggered the creation of super PACs. But again, dependence corruption could, depending upon the factual predicate, since the focus is upon the attention of government officials as they get distracted by this growing dependence on well-funded super PACs. And finally, Buckley's focus on quid pro quo corruption doesn't make clear the compelling interest in publicly funded elections. But dependence corruption certainly does. Only publicly funded elections, whether the top-down sort upheld in Buckley or the bottom-up sort increasingly popular among reformers, could produce an election cycle where members were not dependent on a tiny slice of us who are not, because of that tiny slice, quote, the people. So, in short, it's Robert Post, I believe, who has helped us recognize the constitutional domains within our constitutional and First Amendment tradition, and as powerfully illuminating as his characterization of that tradition has been in these lectures, in the battle between RR and DD, Republican representation and Democratic deliberation, with the ironic twist that it's the left who is RR and the right who is DD, a more properly Postian response would have tried to bridge the gap between this RR and DD, maybe a bit more artistically, with RD, with this republic domain, within which representative integrity is protected and for which both Rs and Ds have an important ideological loyalty. That is a foundation I think Post can stand on, and one the court should be more easily able to recognize too. For as attractive as the idea of electoral integrity is, and as true as the claims of an empirical foundation necessary for a republic are, the reality of the way constitutional jurisprudence will work is that it is enormously difficult to imagine the court grafting onto its 100-year jurisprudence, or even 50-year jurisprudence, a limb which purports to reestablish an idea which should have been there from the very beginning. I think that idea has been there from the very beginning. I think this idea of corruption is core, and I believe there's a way for the court to recognize it and thereby to complement exactly the intuitions that motivate Robert Post's extraordinary lectures. Thank you.
So do you want to exercise your own rights, your own free speech rights now?
Make it a public domain.
Make it a public. Yes, if you would please line up to ask your questions, I think that would be simplest. Jenny, please say who you are.
In trying to understand your...
Jenny, would you please say who you are?
Oh, I'm sorry. I'm Jane Mansbridge from the Kennedy School of Government here at Harvard. In trying to understand your theory, I have two questions about one sentence. When you were describing electoral integrity, you described it as you're asking the question, are elections structured in such a way that the public can have trust and confidence that the elected officials will be responsive to public opinion? So later in your talk, you brought up the issue of corporations and distinguished between corporations and other people, and made various arguments about that. I don't see how corporations enter into that. My first question is, how do corporations enter into that question? Because the trust and confidence that the officials will respond to public opinion could surely be distorted just by knowing there were rich people, individuals out there. And whether the money that distorts is given by corporations or not seems to be irrelevant to that core question of yours. So that's question one. And then question two is a quite different question about this, which is the role of actual subjective experience, which in the first part of your talk you stressed. But if I could just focus on the word "can" in your question. Are elections structured in such a way that the public can have trust and confidence that the electoral officials? You don't say that the public does have trust and confidence. And I think that your use of the word "can" betrays a little bit of a deviation from your earlier stress on actual subjective experience, because you're moving then into a more hypothetical, I won't go so far as say Rawlsian or anything like that, but a slightly more could they, can they, could they, might they, in a more hypothetical world, not actually do they. And so I think that you are moving a little bit, that you actually in fact hold a bit more of a kind of hypothetical, deontological set of assumptions, and less ones grounded in actual subjective experience. So those are my two questions about that one sentence.
Those are great questions. It's a little bit of difficulty with oral presentation. You're sloppy, but I am. But so the first question is, what does that do with corporations? And the short answer is, I was dealing with this case, which is dealing with corporations, but you could generalize it in the way you describe. The principle under which one would generalize it is the principle I was trying to explain with electoral integrity. And I would say the difference I had with Larry, and Larry's excellent comments, was use the language of dependence. I would use the language of responsive to or something like that. But I would say to public opinion as opposed to the people, because I want to make it not something definite, and I want to make it to a process which is itself normatively constructed. So, I mean, I think that would be a difference between us. And on your point about corporations, there's nothing specific about corporations, except the following. When yesterday I was quoting Brandeis about what public opinion consists of, it's the result of what we all have to say. Are corporations properly conceived a participant in the melange that make public opinion? Answer is no. If they were to be excluded from it, it would still be as legitimate a public opinion. The only point about corporations is they distribute information to people who are properly within the contestations that make public opinion. So the public opinion to which government ought to be responsive or dependent, to use language that Larry was using, is not, in my view, does not include corporations, properly speaking. So that's the distinctive quality of corporations. And second, your point about can have trust and confidence versus do. I have to think about it. I'm probably going to want to weasel. I'm going to want to say first, if they don't, that's a problem. So that's a fact. Second, do they? Undoubtedly, this is going to be a matter of judgment. There's going to be a lot of room for, argument about do they or don't they now. Is it such that the conditions that we lay down or think of as prerequisite are broken? If that's true, then they can't, right? So I want to go there, but I don't know exactly how to put it logically, but you put your finger on a good ambiguity.
Do you want to just elaborate a little bit on what you touched on, the difference between the two of you on that? I think the audience might find that useful.
Well, in the written version to which Larry was responding, and I didn't go into it because of time constraints, I do categorize Larry's wonderful book as a variant of the distortion theory, because he does in the book talk about the baseline to which government must be responsive as the people versus the funders. And the people in that formulation have to have a definite content. these are the people, this is the aspect to which government must be dependent upon them. And so it has the aspect of appearance and plenitude to which I was objecting when I was invoking Claude Lefort and Nadia's work and so forth and so on. And so it's that tendency of it which I would... Now, when I say dependent upon public opinion, I'm using public opinion here in a way which is ultimately circular, because public opinion is constituted by the communicative rights through which it is maintained. And one of the things I'm saying is if the rights are such that public opinion loses the force of electoral integrity, the confidence and trust, that's a reason to reshape how we imagine the public opinion to which government must be responsive. So I understand I'm in the middle of something that's a recursive and probably circular, but I think it's a virtuous one, not a vicious one.
Barry, do you want to say something
Yeah, so,
quickly?
I mean, I guess the response is that it's not a distortion theory, because I don't understand there to be distortion because I have a sense of what the people want and I see it as being different. I have a sense of it being distortion because I see the responsiveness is to a group that is not the people. So it's the raw improper dependence. And I guess I would suggest, everything you said about corporations in this, I would agree with completely. I wouldn't quibble with any of what you've said. But what's missing from the presentation, I think, is the scale of significance here, right? So in the last election, corporations, of course, they can't make direct contributions at all. And of the independent expenditures, they were 11% of the independent expenditures. So imagine Citizens United had gone the other way and said, no, corporations can't have anything to do with this. Still, we would have a republic that suffers deeply from your representative integrity. And then the question, so you make it sound like there's a whole bunch of work being done by clearing out corporations, but from my view is, we haven't begun if we clear out corporations. And then what more do we do to deal with this fact? And how do we even articulate it so the court could hear it and not imagine you were getting to a morass of Turner decisions, which are disasters.
Well, may I just...
Absolutely.
So I think that's, what you're saying is right. And for reasons of time, I didn't go into... There's another way to look at this problem. I think corporations, as you say, is the tip of the iceberg. And in fact, we have good reason to think that corporations don't spend a lot of money electing candidates. They spend their money lobbying. But I do think we have the resources within the First Amendment to imagine a way of structuring the constitutional question which will allow us to talk about individuals who are rich, not merely corporations who are spending money. And I was talking corporations for these purposes because of time and focus on Citizens United, but the larger point here is if electoral integrity is worth preserving, what are the First Amendment resources we have for preserving it? And I gestured toward this only in the oral presentation, but when we have an end toward which we structure government, say an organization. Within the organization, speech is regulated instrumentally toward that end. And I call that structure, as you know, a managerial domain. And there are good reasons for thinking of elections as managerial domains. So if you look at the Australian ballot or you look at the direct primary, before elections are private contests in which you printed your own ballot, you had your own relationships to it by nominating the candidates through your own convention or whatever caucuses you wanted to do. And because in our past, this was thought to put electoral integrity at risk, the organizational boundaries of the election are expanded to include the ballot and then the nomination system. And this has consequences for speech. So in any state with which I'm familiar, you can't make certain statements in a polling place because that's viewed as inconsistent with the purpose of an election, which is the free and unconstrained choice of your candidate. So though that's bounded geographically by the polling place, but we can imagine conceptually it going out to the campaign around it, which is also affecting your ability to freely and unconstrainedly choose your election. And in most countries in the world, many countries I should say, elections are viewed as a managerial domain. That's true in Canada, it's true in Great Britain, and that means you need a contrast between electoral speech and politics. And that's a very difficult concept, but conceptually it's simple, and I think we should go, I suggest, if the empirics are such, we could go there constitutionally. And then this issue wouldn't be bounded simply by corporations, and I don't think corporations are the heart of the problem. But I bring up corporations because it shows how obtuse the court is in its First Amendment reasoning. Even so simple a problem as corporations, which present a completely different First Amendment set of problems than that of the speech of ordinary persons, the court can't even get that rudimentary distinction. So this more complicated distinction takes more work.
Thank you.
Thanks. Jed Schwartz, up here, Jed Schwartz. I'm a writer. I have a question. Ken, first place, I hope you publish this, because I had trouble following it, the intricate arguments and everything. But you did mention, no, I'm a little slow. I mean, and I'm not a lawyer. So can expressive organizations such as you referred to, like corporate, for example, media, TV networks, still be regulated? It used to be the case that there was a requirement that corporate media had to present multiple sides of arguments, or I may perhaps better, both sides of arguments, or if you want to make a extrapolation to like Rawlsian theory, that there had to be some kind of fairness of presentation. It seems to me that that is no longer the case whatsoever. Does this lead to a case for public media financing rather than private-owned and financed media corporations, which, yeah, sure, but you could just finish. I mean, just a couple of more sentences. Note that now public broadcasting in the U.S. is actually corporate-owned media broadcasting. Allowing corporate media ownership implies that media editorial decisions and topic selection are up to the decisions of the highest bidders.
Thank you, sir.
Okay.
Thank you very much.
Well, there's a number of questions there, which are good questions. First is my own preferred policy solution. I mean, in these talks, I'm simply talking what is a constitutional framework for analyzing it. I'm not talking policy, what's the best solution. My own solution would be to have floors, not ceilings, to have publicly financed elections. I view that as an optimal solution, not campaign finance control. But that's a separate issue than how should we debate this constitutionally first. Second, one sees the argument, one sees it even in Citizens United, that unless corporations could have individual speech, there can be no freedom of press because the press is corporations. New York Times is a corporation. I think that argument is silly. We have a separate set of protections for the press, and those are oriented around the constitutional functions of the press. Corporations that have that function should have those rights as distinct from ordinary commercial corporations, which should not. So what the press has as press is distinct from what a corporation, qua corporation, has. Third point that you make is we used to regulate the broadcast media. I think that was at the heart of it, and now we tend not to. And it's very interesting. The case that justifies that is Red Lion. And in Red Lion, the logic goes as follows. Broadcast frequencies are a scarce resource. It's foolish, said the court, to imagine that everyone can speak as they wish on the broadcast media. So we give licenses to certain groups like CBS or a station, and we say they are a trustee for the rights of the public. So we don't conceptualize them in Red Lion as a speaker. We conceptualize them as a trustee for speakers, and hence we can regulate them in this Micheljonian way, regulate their allocation of the resource frequencies to better inform the public, hence the right of reply rules and the fairness rules which you're referencing. As the decades progressed after Red Lion, the court began to reimagine corporate licensees who get broadcast licenses not as trustees but as speakers themselves. And so they began to attribute to them the rights of speakers and lost its grasp of this conceptualization of the problem. And that's why we are where we are now as opposed to where we were, 1968 when Red Line is decided?
Hey, would you?
Steve Helfer, law school library, retired. It seems to me that the legitimation, I think is the word you used, of the electoral process, which you say is subjective, is so vague and so broad that it could be used for almost anything. Now, in the Citizens United case, you had, I guess you would call them a non-expressive corporation, because I'm not sure of your distinction between expressive corporations and non-expressive corporations. But it was a nonprofit corporation, an assembly of people dedicated to the political process, and they were told they could not distribute a movie they had made. It was criminal speech because of this law. Why is it, again, that maybe the New York Times can do something close to an election, but Citizens United or the ACLU is prohibited?
Well, I didn't say anything at all, one way or the other, about the particular plaintiff in Citizens United. I don't actually know, but it's perfectly plausible to me that a narrow solution to that case was this is an expressive association, so it's like a person talking. I actually don't know the facts, and if it were, that would be an appropriate resolution of that problem. As I said in the talk, it's not the corporate form, whether it has a corporate form that's determinative, it's our constitutional characterization of the kind of association that we have. And the kind does not mean corporate or not. It means why are people getting together to make this organization? Are they getting together to talk? In which case it would be like the Massachusetts case that I mentioned, Citizens for Life. And that's the point about Citizens United plaintiff. And I'm not making any claim one way or the other about that. I'm making a claim about the way in which the court reasons about the problem, which doesn't turn at all on the specific characteristics of the corporation involved in the case. Now, your first point about electoral integrity being vague and broad, I quite agree with you. It can be vague and broad. That doesn't mean it's useless, and it doesn't mean it's not important. Many of our most essential concepts are vague and broad.
Thanks very much, Dean Post. I'm Sabir Rahman, a fellow at the law school. And I want to ask about the concept of democratic legitimacy, subjective experience you sketched out yesterday. My question is kind of the scope of that idea. To what extent is discursive democracy and electoral integrity that you talked about today exhaustive or sufficient, in your view, to meet that ideal of democracy? Because thinking through, it seemed that I can see how they would be necessary. It's not clear to me that they would be sufficient. You might need a whole host of other institutional arrangements. And related to that, a question about your interpretation of the progressives. If you take a broader look, not just at Lippmann, but say Jane Addams, John Dewey, others, they're not just appealing to public opinion, but also a bunch of other arrangements, social movements, home rule, regulatory institutions. And so I just wonder if you could say a little bit about how you see the idea of democratic legitimacy relating to other areas outside of electoral integrity.
Well, the first answer to your question is very clear. It's necessary but not sufficient. I mean, a whole lot of other sufficiency conditions that we can talk about and which can be absent and which can destroy legitimacy and which need to be taken into account if you're looking at it. So I'm completely clear about the first answer. The second, there are regions of social life in which we want democracy. For a while in our national life, it was fashionable to talk about industrial democracy, democracy in the corporate, in the cutting room floor and the machine floor. So this is a concept that could be relevant wherever we want to have actually the forms of authority for which democratic legitimation would be appropriate. That's not everywhere. It's some places and not others. And we can talk about where. And when we do have it, then we need to talk about why it's there and which parts of it to import. And we can import some elements and not others. And so I'm not making any general claim about its general applicability.
I'm Christine Joles from Yale Law School. A number of years ago, in the same room, Justice Breyer gave his Tanner lectures. And like today's lecture, they urged the adoption of a kind of general framework and urged the rejection of simple, bright-line rules to constitutional interpretation. And the first question was asked by Larry Summers, who said, if all judges, or even a lot of judges, were like you, I'd be happy with your approach. But since they're not, the bright line approach is better. And I guess I have the same question for you.
Well, I have no illusions that I once saw a debate, actually, between Ronald Dworkin and Andrea Dworkin, if you can imagine. And it was about the regulation of pornography. And Andrea Dworkin is saying, you can imagine what she's saying. It needs to be regulated. And Ronald Dworkin looked at her and he said, well, you have to make rules. When you make rules, when you make laws, you have to imagine them being enforced by your worst enemies. And I actually think that's a profound insight and one to which I agree. I don't think the answer that counsels that we only have bright line rules. I think that counsels that we build our law on core areas where, in point of fact, there are shared commitments. And what I've tried to do in the second lecture is to develop what I take to be a shared commitment on all sides of the court. I don't think there's a justice who would be opposed to the value of self-governance. I don't think there's a justice who would say "fait" if you said self-government is at stake. And then the next question would be, okay, so how does it get realized? And it could be the basis of a dialogue. I think what my own jurisprudence is that law is erected not on rules. Law is not a system of discipline. Law is a system actually of the unfolding of shared values. And so we want to make it as receptive to shared values as we can, while at the same time making it as immune from opportunistic and strategic manipulation as we can. And those are two values that we try to maximize in the rule of law.
So, but I would say, I think we can say that there's a preference for one over the other. And so I guess in response to what you've presented here, my own view is that we could get most of what you're concerned about without embracing what feels like a very vague, malleable, fact-based analysis. And so then the question is, if we get 90% of it with a more tractable standard, is that good enough? Because the cost of the more malleable is much greater. So we could have a preference for structuring as much as we can in this ordered way, and then be forced into yours if that fails.
At the margin.
Yeah.
Yeah, why not?
Okay.
Hi, I'm Tim Scanlon from the Department of Philosophy. Robert, in your elegant analysis, a lot seemed to turn on identifying discursive democracy as the specific concern of the First Amendment. You often mention, well, equality and distortion might make sense within the framework of representative democracy, but that then would conflict with the First Amendment interests, which have to do with discursive democracy. And you made a similar contrast in looking at the Canadian case. And I just wanted to call some people's attention what seems to me the very special character of that, perhaps narrow character of that identification of the First Amendment. Discursive democracy is a process, as you understand it, through which we all participate in shaping the ever-flowing river of public opinion. And what that river actually is at any given time, as you said, is indefinite. It's not like a political decision, but that doesn't make it unimportant or unimportant to the First Amendment. A law that tried to regulate who could hold hands in public or who could write stories about people holding hands or showing affections to them in one way, to each other in one way or another, would be a violation of the First Amendment for a variety of reasons, but for one, in it prevents people from participating in the formation of social mores and what's acceptable personal contact and way to live and so on. And that's very, very important. But what I find a little bit strange is the idea that that important form of participation just is what the First Amendment is about. Even in the political realm, you mentioned Meiklejohn, who has a very different idea about the centrality of democracy to the First Amendment, but it has a different idea about how it is that the kind of activity that the First Amendment protects is crucial to the democratic process in one way or another. And one might think that the First Amendment, some of us think, protects things outside the political realm, like scientific inquiry and other decisions about discourse about how to lead our private lives. Now, maybe political discourse is particularly important. I would agree about that. But the idea that protecting discursive democracy is the thing, particularly if discursive democracy is understood as mainly valuable because of producing what you call electoral legitimation, which is the subjective experience of participating in this process in the perhaps justified, or to some degree justified, belief that the political actors are responsive to it. Well, the two parts of that puzzle me are the focus on the subjective on the one hand, and on the other hand, the focus on the idea of the governments being responsive to this ill-defined thing. Just because it is ill-defined, that's hard to focus. Now, I don't think that all of that is unimportant, but because of those features, the subjective character and the indefinite character, it seems to me odd to simply identify it with the First Amendment and see these other things as conflicting with First Amendment values.
Sure. I mean, as you know, this is a long-standing debate that I have in this area with people like yourself and Shauna Schifrin and so on. But the lecture yesterday was an attempt to motivate this account of the First Amendment, not simply by saying it, which I've done in the past, but by actually showing the emergence of it First Amendment rights that didn't exist before as a solution to this problem. You know, we had libertarian impulses way before we had First Amendment rights. We had the impulse to protect private life way before, and private autonomy way before we had First Amendment rights. And indeed, First Amendment rights come in precisely as the administrative state is emerging and de-emphasizing the private autonomy rights, and it's doing it by way of solving this problem of representative integrity in the United States. That's the brunt of the first lecture. Now, in this lecture, I don't actually need to say it's this and only this, because on no plausible account is there any other version of the First Amendment that is relevant to the issues of campaign finance reform. So campaign finance reform is not about personal autonomy, because it's about corporations. It's not about, I mean, so it's very hard to think of any account of the First Amendment that wouldn't be grounded in something like this, that would be relevant to the things that we're thinking about in the context of campaign finance reform. That's a second point. A third point is when Kennedy explains why he's protecting it, he uses exactly the language I'm talking about, namely, this is necessary for our democracy, not for private autonomy. And then a fourth, by way of distinguishing what I mean when I talk about freedom to participate in public discourse, I mean public discourse, and then this is a complicated thing, it would take a long time to explain, but basically participation in the public sphere. That the political, non-political, that's not a substantive distinction, that a democracy is a form of government which is created in a complementary way to the creation of the public sphere. It's inconceivable without what Habermas would call the public sphere. And the public sphere is not delineated by labels like political or not political, but its consequences are political, and it's the freedom to participate in the public sphere which is essential.
May I follow up just quickly? The public, I'm prepared to sign on to the importance of the political and the public sphere entirely. I'm not an autonomy theorist, contrary to what some people think. But it was the particular focus on this participation in discursive democracy as opposed to other forms of political participation in electoral politics, which might also involve speech, that seemed to me to be what was at issue.
So if you were to be serious about a Micheljohnian account, you would never have the form of reason that you have in Citizens United. Because Micheljohn says, he precisely advocates the structured regulation of informational processes to the public. He would never condone a flat rule prohibiting distinction between speakers, because in the paradigmatic Micheljohnian case, which is the town meeting, we always distinguish between speakers. We do it in the interest of the orderly presentation of information. So there's nothing in any of the rules which Kennedy sets out and says which would be consistent with the Micheljohnian account. And in point of fact, in the written piece, I say you could give a Micheljohn, if you really cared about informed decision making, which is the basis for the protection of corporate speech rights, ordinary corporate speech rights, a better approach would be to be a Micheljohnian one. And so to structure this in a Micheljohnian way to increase the flow and the quality of information to the public to the end of more informed public decision making.
Larry, do you want to say something?
So, Robert, you delivered on the hopes that you raised yesterday by offering a way to rescue within our constitutional discourse an avenue to actually reject Citizens United and put us on a better path. However, during the course of your talk, I had two words alternating in my mind: fiction, reality. Fiction, reality. So I'd like to ask you, and also Larry, to meditate, or at least contribute to, a discussion about how should we imagine the way in which an actual Supreme Court, maybe ours, maybe another one, would conceive of the issues that are signified by terms like discursive democracy, would react to terms like corruption, when it seems that the discursive democracy that you describe has so little relationship to most people's actual experience. I give one anecdote. I'm in a taxi cab. The taxi driver, who happens to be a woman, says, "Do you mind if I stop to buy a lottery ticket?" I'm on my way to go vote. I'm worried about the poll closing. I say, "Okay, but I have to get there before the poll closes." She says, "Oh, that's so interesting." I said, "You have to get the lottery ticket now?" She says, "Yes, I get it every week." I said, "Gosh, that's interesting. I've never purchased a lottery ticket." She says, "That's interesting. I've never voted. So that is not uncommon. You look at the statistics in the United States, you look at a phrase like the integrity of the electoral process. Is that something that is likely to elicit a sense of, yes, this is something we believe in and it's in jeopardy, whether by the Supreme Court or by ordinary people, or instead, well, that was a nice idea, but we don't have that. And then how should we understand the nature of your intervention? To whom are you speaking? Is this contributing to a kind of marketplace of idea or aspirational language to which we should conform, or fiction versus reality?
Wait, I have to answer that first?
Why not? All right. So, yes, of course, these are ideals, these are principles, and they're honored as much in the breach as not. You know, if you look at political participation in the 19th century, it really does correspond. Is Nancy here? Yeah. No, left. So, I mean, corresponds to Nancy's idea of partisanship, where you have huge identification with political parties, you have high turnout, you have high identification with the political system mediated through the party, and after the 20th century begins, this declines. And so when we speak about democracy, we're speaking about what we want, and which it may not have actual, we may not have actual purchase in the lives of people who have never voted, but instead buy lottery tickets, you know. And what do we do about that? So that forces us to have a choice. So do we want to construct our polity with the model citizen, the paradigmatic citizen, somebody who never votes but buys lottery tickets? Or do we want to construct it around someone who could vote? Were they sufficiently motivated to, that had a political process that reached out to them? What do we want to achieve? So I prefer to think about this less as fiction than as ideals. And of course, ideals are always, as you know, fictional, but they are, as Cover says, the nomos, it's a bridge to which we're building our present world. And these are bridges that we build out to get to where we want to be. And the question to ask of them is that where we want to go? And that's an appropriate conversation, but not, people kill their brothers. Cain kills Abel, therefore, and what? So, so I would say yes, you're right to say that, but I would say that's the nature of law. It's a nomos.
Well, no, I would disagree. It's not the nature of all law. And
not
so I
the
think this is exactly it's a fair point, which is, part of what I was resisting in what you presented is just the difficulty conceptually to understand how would you move with this? Like, what would you say? Like, I tried to offer at the end how, the twist that I've offered would actually help resolve real cases. Like, and I think, I can understand how I would try to show that. It would show that there's a reason to have aggregate limits, and it's because of the factual stuff here. And it's not a lot of work to get to that place. So you and I agree that Citizens United is crazy for its kind of Lochnerism about the consequences of the way our current system affects people's view. But on the other hand, we at least want a doctrine that feels like 10 or 20 or 30% of the work is being done by the doctrine, as opposed to fact findings by a district court judge in the face of empirical evidence offered by professors of sociology. Well, I liked them at Harvard, but at other places, right? So I think that one way to think about different theories, fiction in reality is a little bit harsh, but one way to think about different theories is tractability. Like, what are the first three steps? Now, only Pam Carlin is the litigator here, so I don't want to pretend like I know anything about this, but I do have this sense that, what would the first three steps of a brief look like? Feels easier for mine than for yours. And again, I'm not against yours. I'm just saying if we can get a lot of it here, then maybe we don't need to make that move.
So here's an example of where you might get. So in Citizens United itself, you know that this case begins as a very narrow argument about whether the BICRA prohibitions apply to a film of this kind. And there's an argument, and the poor Solicitor General, representative of the Solicitor General, Assistant Solicitor General is arguing the case, and the court asked him, he said, well, would you prohibit books? Because, corporate expenditures for books might be potentially corruptive. And he says, yes. And so there's this moment of like horror, and then doesn't know where to go. And then the court, we know this from Jeffrey Toobin's reconstruction, goes in and then they ask for re-argument. And at that point, Elena Kagan steps in, and she's the Solicitor General, and she's going to say, no, it doesn't apply to books. Why not? Well, that would be foolish. Or, I mean, she gives some argument which actually has no logical connection to the government's theory of the case. And then they say, well, what about pamphlets? She said it could apply to pamphlets. Now, I think that if you have a set of rationales which go down that road, you've got a problem. If, on the other hand, you're going to say, is there a loss of electoral integrity from publishing a lot of books or a lot of pamphlets? I think there's a pretty clear empirical answer to that question. No. There's a loss of potential electoral integrity because of broadcast media, maybe, or because, I mean, you can look at the outlets which are actually causing a loss of public trust, but books and pamphlets are not likely to be among them. So that's an example. So,
but that's not distinguishing your position and mine, because
Right.
because I clearly think Citizens United on the facts is decided correctly. I don't think there's any problem in saying that this nonprofit filmmaker has a constitutional right to spend its corporate funds to promote its film. It's all the elaboration on top of it that is terrifying us, right? So then the question is, between the two approaches, you know, which one is going to be more helpful with the next case, which is not going to be a film case.
So then, if I'm understanding correctly the difference between us, it would be the difference in terms of, what was the word used by the two questions ago? Vague and broad, in terms of vagueness and breadth of the criteria of dependent on versus responsive to, right? I mean, and if those are your choice of criteria, I would say I don't see how one is more practical than the other. I take your argument to be, one, it has originalist foundations, so everyone should agree because they should be originalist. And two, corruption is something that we all care about, and we do have the word corruption in our vocabulary, so it's a smaller step for the court to go down there, and I acknowledge those strategic advantages. Just from my perspective, I want to trade them off for a kind of theoretical point of how it actually integrates with the rest of First Amendment doctrine, not of representative democracy. So the argument you make is in terms of how representatives should function. And it seems to me that the problem in all of these cases is how the value of representation fits with the value of freedom of speech. And the court has been unwilling to talk about how freedom of speech can be infringed upon or impaired even by the values of representation. So it's that first move that the value of representation dependent upon corrupt intersects with freedom of speech. That has been the problem for the courts. So internal to the approach I've tried to put forward is, well, actually, you say you care about the First Amendment, and so do I. And so what does it mean that you care about those rights, and what are the internal entailments of protecting those rights, and try and build it out from what I take it to be their first premise. So that's what I would say would be a difference.
Could I ask you a question which is neither a legal one, and nor a particularly American one, it's a French question. You talked about Lefort, and I too like that work a great deal when he talks about the place of the people is empty. But it seemed to me that in Lefort there's a particular notion of repetition and iteration in the construction of the public and indeed of democracy. And that notion of iteration I didn't find was part of your understanding of public opinion. And I wondered whether you might elaborate the Lefort in the direction of this much more American concept of discursive democracy and the public opinion. I just felt that there was a conceptually, Lefort is doing something in a very different way than...
Can you elaborate his meaning of iteration there?
Yeah, that for him, in a way, I think you alluded to it, that in a way the place of the people is always empty, not simply because something different is happening all the time, but because very different perspectives are emerging into that empty space, and that is part of a non-progressive notion of time.
Right.
It's a much more iterative notion of time. That keeps on throwing or projecting or emerging into that space the kind of ideas you were trying to do.
Well, you know, the passage that I recur to in this context in Lefort is when he says, the people are most certainly absent right after an election.
Yeah.
He says, because their presence is known in this concrete way, and whatever you know about the people, they're not just that. So the question is, what do you mean not just that? And one way to put that is in space. There are more people than that who are there. Or you can put it in time. Namely, they may have been that then, but what are they now? Michael Walzer, when he attempts to give explanations, says that people are, different people join the people, different people die from the people change their minds. The whole thing is a temporal process. And it's always going to be a temporal. So I like to think more in the concept of temporality because what we're wanting is a kind of popular sovereignty, no matter where we are. We want a notion of self-government. And if you dissolve the self in space, you have a harder time grounding the fundamental value than if you dissolve it in time.
Yeah. No, I like the
That's why I'm moving it that way.
Yeah, no, I like the temporal move a great deal, but I just thought you might want to elaborate it in relation to Le Bon. Well, thank you all very much. Let me remind you, before you applaud, let me remind you that tomorrow morning at 10 o'clock in the Thompson Room at the Barker Center, 112 Quincy Street, there will be a full-scale seminar on both these lectures and the various discussions as well as the introductions. There will be a wonderful, rounded discussion of these 2 days. I want to thank Robert. I want to thank you very much, Larry. Thank you. I think it's been a wonderful afternoon, and let's reconvene tomorrow morning. Thank you.